Thank you very much. I think she was trying to say she trusts me with her trust. Just a quick plug and a thank you to Nancy and Rachel. As Nancy mentioned, we've known each other for going on 20 years now, and I know a lot of real estate agents, but I can just tell you that Nancy is always proven to be ethical and professional. And if you ever have any real estate needs, that's your person right there for sure. Okay, so we're going to make this kind of interactive, and I'd love for you to ask any questions you want. I'm going to be covering some of the pitfalls that we've seen as estate planning attorneys that people can generally experience if they're not careful with their estate plan. And I'll tell you some stories along the way to just try to make this interesting. But go ahead and ask me a question if something pops up, and I don't mind pausing and trying to address that for you. So the pitfall number one in estate planning is failing to avoid probate. Now, probate is the process, in case you don't know, whereby if someone does not have a trust or they do not have other what we call probate avoidance vehicles, then the court gets involved. And the court, even though there might be a very clear path and a very, very clear beneficiary for that piece of property, the court has to get involved and say, you know, this XYZ house or XYZ account goes to ABC person. And guess what? They get charged, you get charged for that. They collect a charge, they collect a fee, it's based on a scale for many times making a decision that can be very obvious just because a person hasn't put in the proper probate avoidance vehicles for their estate. So that's why I say failing to avoid probate, right? Everybody remember Sonny Bono, Sonny and Cher fame? Yeah. Sonny Bono had a pretty extensive estate when he passed away, but he didn't have an estate plan. So what happened when he died? That exact thing. His estate went into probate. There was a lot of challenges to his estate, and it ended up being a long, drawn-out, and very expensive process. All of the funds to determine who gets his estate came from his estate. So one of the recurring things that you'll hear me say today is work with your attorney, and definitely you want to implement vehicles that will allow you to avoid probate. So why is probate so bad? Well, first of all, probate is public. So if you have any interest in keeping your estate and your property private, you want to avoid probate because court proceedings are public proceedings, and that means that anybody can look up what you have in your estate. Probate's also slow. If you have a trust or other vehicles for avoiding probate, that's a pretty straightforward process. If you go through probate, this can take a year or longer in a very long, drawn-out process. And finally, it's expensive. As I mentioned, the court's going to take funds from your estate to determine where your assets go. So you can avoid probate and keep your affairs private. You can avoid delays, and you can better manage your estate by putting in place probate avoidance tools. And the number one way that we do that is with a trust. And I like to describe a trust as, if you can imagine a triangle, right? So you've got 3 points on the triangle. At the top, you have whoever created the trust. We call this, they go by a number of different names. The trustor, the grantor, the settlor, those are all the same thing. All that means is that who created this trust, okay? And then you have the point of the triangle down here, and that's where the trustee resides. And who's the trustee? The trustee is just a fancy way of saying the manager. Who's going to manage the assets that are inside this trust, inside this triangle? That's the job of the trustee. These two can be the same person. In fact, they often are, right? And then over here in this corner, we have the beneficiaries. And those are the people who benefit from the property that is inside that triangle. Again, can all be the same person or people. So if a husband and wife are the people who create a trust, they're the trustors or the settlors, They're the ones that generally manage their trust. They're the trustees for their own benefit, and they're the beneficiaries of the trust. And a trust, again, I'm explaining this because a trust is probably the best way that anybody with significant assets can avoid probate. It's not the only way. There are other ways that probate is avoided. For example, if you have an everyday checking and savings account, you don't necessarily need a trust to manage what's going to happen with that account and to avoid probate. What you can do is you can designate beneficiaries. The bank where you hold your checking or your savings or your money market account will give you what's called a beneficiary designation form. And all you do is you designate, who's going to get this account, should something happen to me. And we always do what's called waterfalling. And that's just a word that I like to use to indicate that the smartest estate planning is to not just designate one person. So, for example, husband and wife have a checking and savings account. They designate their daughter as the beneficiary, and off they go. What happens if their daughter isn't around when they pass away? Well, that asset, it goes to probate, and then the court has to figure out what's going to happen with it. If there's a waterfall, meaning they designate their daughter, then they designate their son, then they designate, a niece, chances are that's good, solid estate planning. They've gone 3 levels deep and they've covered it. So beneficiary designations are another way you can avoid probate. Joint tenancy in a real estate asset is another way of avoiding probate because joint tenancy has right of survivorship. You guys all know what that means, right? So you have 2 joint tenants. One of them passes away. The other one gets the right, because they are the survivor, to the entire asset. So that doesn't need to go through probate. All I'm trying to say is that there are ways that you want to avoid probate, and it's the number one mistake that we see in estate planning is failing to take these measures to avoid probate. Okay? Pitfall number 2, planning too late for your incapacity. Everybody remember Glenn Campbell? I guess he's country, right? Country. Glenn Campbell had several children, and he had an estate plan. But in his estate plan, he didn't account for 3 of his children. Then he was diagnosed with Alzheimer's. Guess what? It's too late for him to make any changes to his estate plan and account for these children. And it's really too late to go to him and say, hey, can you clarify what your wishes are for your property relative to all your children, especially these 3. Why? Because he no longer has capacity to do so. So planning for incapacity is a very, very important concept that people should consider when they're doing their estate plan. If you're unable to manage your affairs, it's really too late to make those decisions. Now, there are some caveats to that. At the point in time where a legal decision or a legal document is executed as per your estate, whether it's a trust, that's an estate planning document, or a power of attorney, that's an estate planning document, an advanced healthcare directive, etc. If you are lucid at the time that you are executing that document, it's valid. But it's hard to prove that somebody who has a known mental capacity was lucid at the time that they executed that document. So you can see how difficult it is once someone is diagnosed with or known to have some sort of incapacity. You can see how easily that estate can be challenged. When we're talking about challenges to an estate, beneficiaries challenging, like I should have gotten more or I should have gotten something. There are really 2 ways that these challenges arise. Number 1 is undue influence, right? So general example and very common is where you have a caregiver for an elderly person, right? And the caregiver ends up with, a big portion of the estate or perhaps all the estate, right? And somehow the children are left in the cold. The argument would be that the caregiver, sometimes the argument is, the caregiver exerted undue influence over this person and convince this person to give them everything that someone else should have gotten. That's one way of challenging, a common way of challenging an estate. The second most common way is simply by challenging the capacity of the person whose estate is being distributed. And the way that looks is that, some beneficiary or somebody who thinks that they should have been a beneficiary goes to court and says, hey, time out, you can't distribute this estate because I should have gotten X, Y, Z. And despite what it says in this document, this person didn't have the proper capacity, usually mental, but it can be other, didn't have the proper capacity to designate what they really wanted with their estate. What they really wanted was for me to get something. So the point is that don't wait too long. If you need to put together an estate plan or you need to update your estate plan, don't wait too long. Certainly don't wait till there's potential incapacity issues. How do you plan for incapacity? Well, there's a lot of different ways. I'm going to be repeating this again. First of all, you want to designate successors and beneficiaries. So a successor is somebody that is designated to manage your trust, if you have a trust, should you become incapacitated. So, let's say you're a single person, you have a trust, you have a child, they're trustworthy, you designate them as your successor trustee should you become incapacitated. And again, here we go again. You want to waterfall that. Don't just name one person, name a second, or even name a third should that person. You never know when that person might not be in a position to step in and act in your behalf because of what's going on in their life. But designating successors is one very, very good way to plan for incapacity. The other way is with your other estate planning documents. Let's just take a second here when I say other estate planning documents. Very generally speaking, there could be more certainly, but there are 4 primary components to a proper estate plan. And that would be your trust, your will, each person would have a will, your power of attorney for financial purposes, and your power of attorney for medical purposes. And you can designate an agent or somebody to act on your behalf for each of those things. And they don't have to be the same person. And let me explain that. When you pass away, it's very likely that it's going to be an emotional process. You might designate your daughter to act as your financial power of attorney because you know your daughter to be level-headed. She's going to be somebody who, for example, can work really well with bankers, with lawyers, with financial institution people. She's going to be perfect for that. However, your daughter doesn't necessarily know your wishes or may have views contrary to your wishes when we're talking about medical care, right? Therefore, it might behoove you to pick somebody else who might be better suited for that role. Just an example of a way, as attorneys, when someone comes in to do a trust, it's our job to ask these questions and to flesh out these issues and to make sure that your wishes are carried out exactly the way you want them to be with the right people that can step in and take care of that for you. So another way to avoid this issue that can come up with incapacity is to select your proper successors and your agents. When I say agent, by the way, you've heard the term agent, you've heard the term fiduciary, you've heard the term attorney in fact, kind of all talking about the same thing. Someone who's going to step in on your behalf and act to make sure that your wishes are carried out as per your estate plan. Okay. The third pitfall, failing to plan for family harmony, right? It's always amicable, right? There's never a challenge, right? I wish that was the case. This is probably the number one reason an estate plan fails is this waterfalling thing that I've been talking about. People think that they're doing a really good job, or their attorney, oftentimes it's not an attorney who's preparing their estate plan. They say, okay, great, give me the name of somebody that can act on your behalf in the event of XYZ. Oh, put my daughter, Jane. Okay, Jane, great. Let's go to the next one. Again, Jane might not be around. It doesn't necessarily mean that Jane is not around, that Jane can't act for you. Jane might have a life event that prevents her from having the ability to step in and act for you. So I can't emphasize this enough. You're going to hear me repeat this, but you really want to make sure that you're naming people that can succeed in a secondary position when you name them, and in a third position when you name them. Okay. Oh, this next one is interesting. Disinheriting somebody. So I had a client come in recently, and she said, Ruben, I want to disinherit my daughter. And I said, okay, tell me more. And she gave me this big long story about why she didn't approve of her daughter's lifestyle and how they didn't get along. And I don't judge. I said, okay. And she says, she used the word disinheritance, I don't know, 20 times maybe. And she says, I don't want her in my new estate plan. And we talked about it quite a bit. Ultimately, what we ended up doing was not technically disinheriting her, because it was her wish that the estate plan be absolutely clear that she considered giving something to her daughter, but she opted not to. What we ended up doing, and this was her selection of a dollar amount, not mine, is that in the estate plan we gave her $1,000. She had two other children who evenly split the remainder of her estate. We put in some language that said, something to the effect of that we understand that there's an unequal distribution. It's our intention that this distribution be unequal. And think about that for a second. Had we just disinherited the third daughter, she has an argument. Some can argue a good one or a bad one, but she has an argument that, hey, mom passed away, she simply forgot about me. She didn't mention me anywhere in her plan. She knows she has 3 kids. She was of full capacity when she died. I'm entitled to a third of the estate. Instead, what we have is a document that says, hey, I know you're here. Here you are. Your name's there, full name. I'm giving you $1,000. And I comprehend that this is an unequal distribution. It's a lot harder to challenge. So we didn't end up disinheriting the daughter, but I think we went a long way towards realizing her wishes as to her estate when she passes away. Disinheritance is a really, really big one. Not updating your estate plan after life changes. Okay, what's a life change? Loss of a spouse, yeah. Marriage, divorce, the birth of a child, whether it's your own child or a grandchild or a great-grandchild, acquiring an asset like a new piece of real estate. You know, Nancy and Rachel help you buy something, and you may want to put that in your trust. There's a lot of other reasons. Moving to a different state with different laws. Some are community property, right, Regina, and some are not community property. I mean, that's a great reason. A lot of people just fail to update their estate plan. We did this seminar earlier this morning, and somebody asked the question, how often should I update my estate plan? I don't know about the updating part, but you should at least check it every 2 or 3 years. Just check it and read through it yourself. Any attorneys in the room? Okay, well, you don't need to be an attorney. Just read it and determine whether or not you think it still is good, or come to your attorney and ask them. And we may say, hey, this is great. You haven't had a single change, no changes, no charges, go on your way, you know?
Maybe this is implied, but if you move to a new house, you absolutely should probably have it updated.
Okay, Everybody get the question? Okay. Your house, especially in the Santa Barbara area, or let's just say in California in general, is probably going to be an asset worth a lot of money.
Yeah.
That asset definitely should go into your trust.
So it's not like your residence in a trust, it really is this residence, it needs to be in detail, what it is.
Yes and no, and I'm going to explain. In order for any property to be funded into this triangle that's your trust, the title to the property has to be in the trust.
Gotcha.
The deed that is recorded has to reflect that that property is trust asset. Okay, so that's the yes part. The no part is that if you own a property on 123 State Street and you sell it and you buy a property at 456 State Street and you're smart enough to put that new property into the trust, does your trust document have to be updated? Not necessarily. No. Why? Because the deed to that property clearly indicates that it's already in your trust. Should you pass away, that property gets distributed as per the instructions in your trust. Okay? Now, is it a good idea to have a schedule at the end of your trust document that lists all of your major assets? Yes. Is it imperative and will it cause your estate plan to fail if it's not? No. As long as it's entitled in the trust. Okay? Yes, sir.
I've heard that there's some way that you can pass your property or house to like in our case, our son, we only have one child.
Mm-hmm.
But by signing a document, it's filing it with the county clerk that says this property is transferred to so-and-so at my death.
That is correct. That's called a transfer, TOD, transfer on death deed. That is a probate avoidance tool. I have a good buddy. His name's Mike. I'm not giving anything away right here, am I? Mike is the youngest of 3 siblings. And Mike's mother had passed away years ago. His dad was still alive until recently. And he started failing, and he didn't have a proper estate plan. So Mike was actually smart, and he went to his dad and he said, hey, Dad, look, at the very least, execute a TOD, a transfer on death deed to me. And that way, the minute you die, we're avoiding probate, I get the house, and then I can distribute it as per your wishes or as per I see fit. And that's exactly what he did. Now, that's a really good thing. The only bad thing is that it doesn't give the person who passed away the management of how they want that asset treated. So for example, if you really want that house sold and you want it distributed, or if you don't want it sold, or if you want to let your partner live there for the remainder of their life and then you want it sold, those are all things that can be accomplished through a trust and proper estate planning, but they're not required. You can take care of the asset, transfer it properly, and avoid probate through a TOD. Yeah. Any other questions on that? So, yes. Life changes, right? Very, very important. Everybody remember Aaron Spelling? You know who Aaron Spelling is? I think he did Charlie's Angels, right? He was a producer of Beverly Hills 90210 and 1,000 other shows. Did he do Twilight Zone too? So he didn't properly, in the estate planning world, the details are kind of fuzzy, but he didn't properly account for the inheritance that his daughter, she was an actress, I'm forgetting her name, Tori Spelling, is that right? Thank you. So she gets her inheritance and she says, this is impossible. My dad was worth millions. I should have gotten more. He was incapacitated at the last part of his life, so it's kind of hard to determine what his true intentions were, and there was a big to do. Anyway, all of that can be avoided with very, very specific and proper estate planning. The other thing I want to mention when you're talking about avoiding family disharmony and I don't want to speak poorly of anybody who's doing estate planning, but if it were me, I would have an attorney who does estate planning do my estate plan. There are a lot of different means of creating an estate plan these days. There's online software. There are organizations and retail shops where you can go to and you can just get an estate plan. I'll just share this story with you. When I graduated from law school, I immediately got a call from an organization that said, "Hey, congrats. Would you like to be an estate planning attorney for us?" And I said, "Well, it sounds good, but I just graduated. I know a little bit about it, but you sure you want me?" And they said, "Well, yeah, it's no problem. The paralegals are going to draft the entire estate plan, but we just need an attorney to look it over and make sure it's all okay so we can say that it was an attorney-reviewed estate plan." And I said, "You realize I haven't worked in estate planning yet?" And they said, "Yeah, it's okay." And I thought, politely said, "No, thank you." But I thought, that's what's going on. That's what's going on out there. Now, could you get an estate plan that was okay that way? I suppose. But I think it's a lot cheaper, even though estate planning is not necessarily inexpensive. It's a lot less expensive than the costs that are going to be associated when someone challenges your estate because it wasn't done properly. Okay. And then the final pitfall is failing to update your revocable living trust. Why do we call it revocable? Because it can be changed, right? This woman that I told you that wanted to disinherit her daughter, she had a trust, but she wanted to change it. And that is the beauty of a revocable living trust. It's a living document, living when you're living, but it's also, I like to say, it's a living document. You can update it as much as you want. Now, an important note on amendments, because I can't tell you how many times people just come to me and they say, "I just need a simple amendment," just a simple amendment. And then you come to realize that this might be the second or the third or the seventh amendment to this document. And it can be very, very problematic for a number of different reasons. One of the most common reasons why these amendments, once you start getting more and more and more of them, one of the most common reasons why it's problematic is because you don't know exactly, as an attorney, how many amendments there are. So think about this. Somebody comes to us and they lay down their trust with 6 amendments. This is what, I need a 7th amendment. Okay, but guess what? There already was a 7th amendment. We just forgot about it. Our attorneys didn't know about it. The client forgot about it. The 7th amendment revoked everything that was prior and put in new provisions. Without that 7th amendment, everything else we do is not valid. The other thing is that these trusts that have amendment after amendment, you need a flow chart to figure out what they were trying to actually accomplish. With today's software, back in the day when all of these things were typed out, okay, there's probably more of an argument for having an amendment. But today with modern software, oftentimes it's just as fast, but definitely more comprehensive and more representative of your wishes to just restate. What that means is we're starting over, we're keeping the name of your trust, the John and Jane Doe Trust dated July 1st, 2025. That way all the assets that are already funded into the trust that have that same name don't need to be touched. We're just taking out all of the old provisions and we're putting in all the new provisions as per your wishes and as per your desire for your estate. So I wanted to make that point because be careful if you go in and you say, "Hey, I just want a quick amendment." Sometimes amendments can be quick. A property changes or you want to swap out a successor or something like that. Oftentimes those are really easy. But what ends up happening sometimes is when we do our job right as estate planning attorneys and we ask these in-depth questions, excuse me, we start to realize that your wishes are really changing here. And instead of us doing a really massive amendment, it's better to just restate the whole thing. Okay. So updates to your revocable living trust are really the final pitfall I wanted to talk about. There are, like I mentioned, a lot of different life events that come along. But if you have a question and you really don't know if there's an event that happened that will trigger a need for you to update your trust, just call your estate planning attorney or call us and talk to us, and we'll let you know if that's going to be something that you really should do. Okay? And that's about it. With that, I wanted to leave some time for question and answer if anybody has any specific questions about estate planning. Oh, come on, somebody's got a question. Tessie.
So if somebody's going to update their trust and it was done with one attorney, can you bring it anywhere to be updated?
Ooh, that's a great one. Did everybody hear that? Essentially, if I can paraphrase, can one attorney work on another attorney's work, right? It's hard because if we're doing our job right, when you come in, we're asking you some really in-depth questions. We're asking you questions about your powers of attorney, your children, your spouse, your assets, and there's a communication of your wishes that get communicated to us, the estate planning attorney. And when we take that from somebody else and we just try to work with it, it gets to be problematic. It's like anybody else. Like, one contractor doesn't like to take over a house that's 3/4 of the way done because they don't really know where the other contractor routed the pipes or put the electrical or whatever. So oftentimes it's faster, easier, and a better representation of your wishes to just start over and say, okay, let's just restate it and really make sure that we're capturing your desires for your property. Yeah. Anybody else? Yes.
What's the usual practice when you create a revocable living trust? Do you keep the original and then you make a copy for the trustor? You make a copy for the two children? Does everybody get a copy, or is that not how it's done?
Yeah, two different issues, and I'm glad you brought that up. So what we usually do is we create a nice binder that has all of the documents that you executed that are in their original form except for the will. Why? Because the original will, should any part of your estate need to be probated, the judge needs to see the original will. So usually an attorney will keep the original will or will instruct you, put it in your hands and say, look, the copy that's in your binder is exactly that, a copy. Put this original in your safe to deposit box or someplace where you know it's at. Okay, that's step number one. Step number two, which is really critical, is to communicate to anybody who's listed in your estate planning documents that they're in there. Tell them that they're in there. Your beneficiaries, make sure that they know that they're your beneficiaries. Did anybody see this New York Times article recently where Warren Buffett recommended that everybody talk to their adult children about what's in their estate plan? I mean, make sure that they know what's going on. Make sure they also know where that estate planning binder is. And inside that binder, generally, we'll have our business cards. So they're not going to know what the heck to do once somebody passes away. We'll probably be the first call. And then we can start guiding the trust administration post-death process from that point on. Yeah.
So when somebody dies, then you get activated, or I guess the trustee starts doing stuff.
Right.
And they work on the documents. But the court, you said it's private, so you don't record it with the county.
No, so
No, yeah.
right, so
That's why it's private.
right, so if we've done our job properly, we are avoiding probate, right? But the estate still needs to be distributed. So what generally happens is that someone passes away, The next person in line, be it a spouse or a child, excuse me, grabs their the deceased estate plan, opens it up, sees our business card, and says, "Okay, I don't know what to do. I'm going to call them." So they call us up and they said, "Hey, XYZ person passed away. What do we do?" And we say, "Well, now it's time to administer the trust." That means do all of the things that are associated with closing up their estate and distributing it to the people who are supposed to get it. And we are advising and directing the successor trustee to do exactly those sort of things. So we work kind of in conjunction with them to tell them what they need to do. Yeah. Does that answer your question? Yeah. Yes, sir.
I was wondering, say 3 trustees have been selected, and you find yourself as the last trustee of the list. Would it be advisable, or how easy is it to go out and get somebody else to be another trustee in case something happens to you?
Yeah, so sure. So if I understand correctly, there was a proper waterfall with 3 successors, and you're the bottom of the waterfall. You're the last man standing. It would be advisable for all the reasons that I mentioned, because heaven forbid should something happen to you.
Go into probate, right?
Exactly. Yeah. Yeah. Because the trust hasn't made provisions for what happens next. So if you know, for example, that you're the last person standing, that would probably be an example of a very easy amendment where we go in and we identify 2 other people. You're now maybe the primary. You don't have to be. And then we name 2 other people.
That was my thought too.
But he can't do that, can he? Whoever created the trust has to.
Right. So before somebody's death, if we're talking about a revocable living trust, then assuming that the person who created the trust is still around, still has capacity, they're the ones that would do that.
I've already administered the money, and I'm still, there are provisions that one person, because of their age, is a little bit every 10 years or every 5 years. So I'm still right in the middle of it.
Okay. So you're in the post-death phase, right?
Yes.
Okay. So the trust document gave the trustees all kinds of powers. It named all of the powers that the trustee can do. Just because the people died, that means that you have all those powers now, right? So you actually, in the trust, I'm assuming that the trust document of the trust that you're administering gives you the power as a trustee to act similar to the original people who created the trust. That means you have the power to name successors.
So that would be stated in the trust?
Should be. Should be. Yes, sir.
Does a trustee have to be a U.S. citizen?
Does the trustee have to be a U.S. citizen? No, the trustee does not have to be a U.S. citizen. But they need to be able to carry out all of the duties of the trustee. So if there's ever anything that would prevent them due to their citizenship from carrying out their responsibilities as a trustee because of that citizenship, not a good choice.
Yeah, well, we've got a son who doesn't live in this country.
Is he not a U.S. citizen, or does he just simply not live in the country?
He was born elsewhere.
Okay. So that raises another question, which is the logistical aspect of it. Oftentimes, somebody doesn't want to be named as a trustee due to distance, right? Because you have to be calling financial institutions and perhaps real estate agents and all kinds of other parties and corresponding with them. And just due to geographical concerns, they might not be the best person. But they could act if you had nobody else and you really felt that this person was the best person and you trusted their ability to do so even from afar, they could act as a trustee. Yeah. Yes.
Irrevocable trust versus revocable.
Okay.
Advantages of irrevocable.
Sure. So what we call a revocable living trust is exactly what I said, is that you can create it, let's say a husband and wife create their revocable living trust. They can change it, edit it during their lifetime. Perhaps it's a better example to just use one person. One person has a revocable living trust. They can edit it. They can change it. they can revoke it. They pass away. The moment they pass away, no more changes. The trust becomes irrevocable. And then the trustee, like this gentleman in the back, steps in and carries out the instructions that are in the trust. That's one aspect of an irrevocable trust. Another aspect of an irrevocable trust is when a trust is created, usually, not always, but usually for tax benefit purposes. So I'll give you one example to illustrate. There is an estate tax, right? I think right now it's something like 13.9 million. It'll probably go down in the next couple of years. Let's say a person has an estate that is valued at, 15.9 million. So they're 2 million over the current estate tax limit. What they could do is they could take that I'm simplifying this. They could take that $2 million, put it into an irrevocable trust, name a completely disinterested, non-related trustee to manage that trust. They can't touch it anymore. It's done, and that trust becomes irrevocable, but is in essence living alongside of them. So there are ways that an irrevocable trust can be used for advanced estate planning purposes. Yeah. Anybody else? Yes, sir.
Is it stated on the trust itself, whether it's revocable or irrevocable?
Usually what happens is it says under certain conditions this trust becomes irrevocable. One of the most common conditions is the death of the settlor, the trustor, the person who created the trust. Yeah. Yes, Regina.
What is the financial limit of your assets for when you don't qualify yet to have a trust?
Oh, that's a good question. Okay, so she's asking essentially, how much does your estate have to be valued at before you should really consider having a trust? There was just a new law that was passed that exempts from probate somebody's primary residence of $750,000 or less, right? But in Santa Barbara, $750,000, we just heard the statistics, right, Nancy? I mean, that doesn't exist. But if you don't have real estate, you don't own real estate, okay? The probate limit is, I think, 183,000. Don't quote me on the exact number. It's 180-ish. It changes every so often. So if you have, these are what we're calling probate assets, right? So if you have like bank accounts and you have jewelry and you have furniture and maybe you have cars, and combined those are less than $180,000, then what you can do is you can qualify for what's called a small estate probate. And it's a simplified process. I won't get into it. It's a couple of forms and some affidavits, and you're done. If you do have real estate, all of those same rules apply, except that if your real estate, the value of your real estate is under $750,000, same thing that I just said. If your estate, okay, that was one instance. Both of those examples were the person was under the limit, right? So now let's talk about if the person's over the limit. Okay, no, don't own any real estate, but I own all kinds of other stuff, and it's worth $350,000. Where you're over the limit, and you're going to be subjected to probate, you should probably look into getting an estate plan. Same exact thing if the person now owns real estate. It's over $750,000. Again, Santa Barbara, it's pretty common. You should probably.
So all annuities, all this other stuff counts as what your assets are.
Let's just chat real quick about what counts and what doesn't, okay? So the things that reside outside of your trust are generally things like your personal property, because you don't have title to your antique, table, right? Your cars are titled with the DMV, your retirement accounts. Yes, they don't reside in your trust, okay? So how do we deal with those? Beneficiary designations, okay? So those are things that are outside of your probate estate. Also, any assets held in joint tenancy, right? Why? Because the right of survivorship, right? So they don't need to go into probate because the other person automatically gets your interest. Okay? So everything else, like, you know, your real estate, cash accounts, checking and savings, money market, brokerage accounts, non-retirement, non-retirement stock, bond, mutual funds, okay, those things should reside in your trust.
Do we have any more questions?
Did I go over? Oh,
No, you're perfect.
all right. If you have any more questions, I'll be sticking around. Feel free to ask me. But until then, I just wanted to say thank you to Nancy and Rachel for letting me be